cases, and then we'll get started with this discussion. First off, case number 24-000040-MM is, for all practical purposes, PV against the State of Michigan Department of Health and Human Services. There's a next friend involved in each one of these cases, but I'm going to refer to the actual minors. The other case is docket number 24-000053-MM. That's AB against the State of Michigan Department of Health and Human Services. Now, I think that neither one of these cases has the sort of procedural defects that are alleged in the other ones. These cases did not start out in the Wayne County Circuit Court. They started out in the Court of Claims. I don't think there's any allegation that we don't have properly verified complaints. I don't think that we have any problems with notice. And so to the extent that those issues are raised in the other two cases, we'll talk about that later. Similarly, since these cases originated in the Court of Claims, we don't have the problem of what's left in the Wayne County Circuit Court and what's here in the Court of Claims. At least as far as I understand it, these are straightforward, procedurally proper actions initiated in the Court of Claims. So what I'm going to do on these two is move directly to the motions for summary disposition. Now, it seems that the way that they're briefed is similar, if not identical, but I see the cases as very different in terms of analysis. The PV case is by far the stronger of the two. In the case of PV, we're talking about a 10-year-old who was assaulted in some significant way, both by employees of the facility and more significantly by another minor who was allowed to come from one part of the facility to the other. The arguments for summary disposition in this case raised by the defendant are similar. In each case, right out of the box, the defendant has asked for summary disposition under MCR 2.116C7 based upon governmental immunity and MCR 2.116C8 alleging failure to state a claim. I'm not sure how far we're going to get on governmental immunity. I spent the last hour reading once again the opinion of the Supreme Court in Bowserman. And it seems to me that a couple things are obvious. First of all, there is manifestly the availability of a claim for money damages for a direct violation of the Constitution. Obviously, there's an exception when there's some sort of statutory remedy provided, as long as it's adequate. But I read with great interest again the concurring opinion of Justice Welch and the majority. And it certainly seems to me that the majority opinion is pretty generous on when you can bring a constitutional claim directly. And then if we get to the C8 argument, I struggle a little bit with the constitutional claims asserted by PV with regard to what's essentially a Fourth Amendment claim and what's essentially an Eighth Amendment claim have to do with unlawful restraint and then cruel or unusual punishment. I just don't see how those can fly, except to the extent that there are allegations that PV's fingers were stepped on by people who work at the facility. And then with regard to the due process claim, I don't think that procedural due process gets us anywhere at all, but I think that there may be a substantive due process claim that's viable. And so I think what I'm going to do is write an opinion on the PV case and the request for summary disposition there. But you should assume that it's very, very unlikely that I'm going to decide it on the basis of governmental immunity. I just don't see that argument after Bowserman. The case of AB, in my view, is quite different. Whether you treat it as barred by governmental immunity or not, I tend to think it's not. I don't see the constitutional violation here at all. as a matter of fact, the pleadings in the PV case refer to AB as the assailant. How in the world her constitutional rights were violated is completely beyond me. So with regard to this particular claim or these particular constitutional claims by AB, my inclination is to grant C8 relief to the defendant without leave to amend, because I think that'd be absolutely futile. I don't know how we could possibly get to a place where AB would have any constitutional violation to assert. So I always try to tell everybody at the start where I'm leaning. I'm always willing to be persuaded, but at least coming out of the box, I think that PV's claim, at least with respect to the due process violation, survives. I'll probably have to grant leave to amend to make it clear that it's a substantive due process claim, not a procedural due process claim. But even if I grant summary disposition under MCR 2.116C8, I still have to allow leave to amend under 2.116I5 unless it would be futile. And I don't see it as futile in PV's case. So with that, let me let you kick it off, Mr. Rothermellos. I understand that you're going to be making the arguments on this one, or yes, these two, I should say.
Yes, Your Honor.
Right.
Both cases.
All right, fine. So why don't you go ahead, and I have a feeling you probably disagree with me on governmental immunity, but you're probably with me at least on AB and the constitutional violations.
Yes, Your Honor. So again, Scott Rothman on behalf of the defendant, Department of Health and Human Services. And I must admit that this is unique. In my years of practice, I haven't had the judge go ahead and tip his or her hand to how he or she is feeling right off the bat. I appreciate this.
Yeah, you know, I used to, when I was a circuit court judge for 14 years, and for a couple of years, I sat there and listened to whatever anybody wanted to say, and I found that the oral arguments weren't focused. And so I thought, all right, I'm going to change the way I do this. I'm going to focus the argument on what I care about. So thank you for following my lead.
I will, Your Honor. So, and I also planned on, and will, for the court's lead, refer to the parties as PV and AB.
Thank you.
So planned on doing that anyway, Your Honor.
Thank you.
So as far as immunity, I just heard the court say, as far as PV and AB, we saw two avenues rather for governmental immunity, and that's the Governmental Tort Liability Act, and then PV and AB's failure to plead. But then, as the court just brought up, it's the Bousman case. We argue that it's inapplicable.
Tell me why, because it seems to me that Smith really set the standard with regard to discussion of the applicability of governmental immunity, and Smith pretty clearly had at least 4 votes for the proposition that if you allege a direct violation of the Constitution, the legislature can't override it with a statute.
Right, and the Bousman court, as you know, Your Honor, placed 2 limitations on the judicial expansion. The first being if the Constitution itself delegated enforcement to another branch of government, or second, and what we believe is applicable here, if the legislature had enacted an adequate remedy for the constitutional violation. And
we all agree the first exception doesn't apply.
Right,
right?
And that's not what I'm arguing. I'm just setting the stage. So we would argue, the Department of Health and Human Services would argue that the legislature enacted MCL 330.1722, which states that a recipient of mental health services who is abused or neglected has a right to pursue injunctive and other appropriate civil relief. And that is, the defendant argues, an adequate remedy for a constitutional violation.
All right, and I was hoping you weren't going to argue that the existence of 42 USC section 1983 in and of itself is sufficient, because then it would be the null set that would be available, because the Michigan Constitution is pretty similar to the federal Constitution in its protections.
No, Your Honor, and that's not our argument. Our argument is pretty straightforward, that there is a statute and it's directly on point.
Right.
It gives plaintiffs an avenue to pursue injunctive and other appropriate civil relief.
Right.
It's right there in the statute, and therefore we argue that it's in line with the second exception for abolishment as far as the court creating constitutional tort remedies.
Let's assume I agree with you, and so I grant C8 in your favor and C7 in your favor. And I suppose you'd argue under I-5 they have no right to amend, but that would make no sense because what you're saying is you can't proceed under the Constitution. Instead, you proceed under the statute. And then I tell them they can't amend to plead the statute. That doesn't make any sense, does it?
To be honest, Your Honor, I hadn't taken that next step as far as being able to amend or not. And so I don't have any particular comment as far as that's concerned.
All right, but my point is, you can't say that they've got an adequate remedy under the statute and then say they can't plead the statute.
Correct. Yeah, you're correct there, Your Honor.
Okay, that helps a lot. Now, play this out with me. If they amend to plead a claim under the statute instead, are you then going to invoke immunity under the GTLA?
Your Honor, at this point, the Department of Health and Human Services cannot speculate as to what we would do. Given
Okay, but right, but is it an adequate remedy if it's barred by the GTLA? It seems to me it's inherent in my analysis about whether I allow them to proceed directly under the Constitution, whether the statute you suggest is always going to result in a claim barred by governmental immunity.
Well, I understand the court's question. I just think the analysis ends at whether there's an adequate remedy or not.
Right, but how is the remedy adequate if it's always going to be barred by immunity? I mean, I'm willing to go down this path with you. I'm willing to let them amend to plead this claim, but I don't want you to turn around and tell me, and now it's barred, so they're done. Right. Because that's not an adequate statutory remedy then.
Well, again, and I hate to sound like a broken record, but if there's an adequate remedy, and and here we argue there is a statute on point, I think then that's where our analysis, I do not want to speculate as to what, because they may amend and they may revise their claim.
Sure.
And so I hesitate to take my analysis further than just that Bowserman states if there's an adequate remedy,
correct, and
there's a statute on point, and at that point my analysis, with due respect to the court, essentially ends at that point, because I don't know how they would amend. They could amend, and well, I'm just going to say I don't know what an amended complaint would look like. So it's hard for me to speculate. Okay, I got it. You see where I'm going, though. It seems to me that at least with regard to with substantive due process, I think PV has the makings of a claim here that survives governmental immunity analysis and that survives C8 analysis. I'm not saying that it's a winner and it gets through C10 analysis, but C8 is a pretty generous standard. And so substantive due process is one of those theories that's a little hard to pin down. I've spent years and years and years thinking about substantive due process and where the limiting principles are, and it's really hard to figure that out. So I'm with you conceptually in the sense that I'd rather have this under a statute than under a constitutional provision that's extraordinarily vague. Yes, I agree, Your Honor. And with that said, would you like me to turn to the C8 arguments at this point? I don't know that I have much more to offer to the court. I think I've kind of I've said our piece. I know the court has read our briefings, and I honestly I don't know. Well, I'm going to persuade you one way or the other any more than I can. Why don't we talk about C8 for a moment with regard to both PV and AB then? Yes. Because it seems to me they've got a Fourth Amendment style claim, they've got an Eighth Amendment style claim, and they've got a 14th Amendment due process style claim. I know that Michigan has similar provisions, but it's easier for me to think about it in that way because the Fourth Amendment violation typically involves the application of force
by somebody who is acting under color of state law. And the same about the Eighth Amendment. Now, if you stop somebody at the roadside and beat the living daylights out of them, that's a Fourth Amendment problem. If they're confined in a facility and you beat the living daylights out of them, it's an Eighth Amendment problem. But here, as I understand it, there is no allegation whatsoever, nor could there ever be one, that anybody acting under color of state law beat the stuffing out of PV, right?
I would agree.
All right. So, and to the extent that you even have people who inflicted harm under color of state law by stepping on PV's fingers, those people aren't really the basis for liability against the defendant here, right? They're off in Wayne County trying to defend themselves.
I believe that's also correct, Your Honor.
Okay, so talk to me a little bit about that. And then with regard to AB, the challenge is really on the other side. I don't see any constitutional violation at all.
As do we, Your Honor, obviously. So you'd like me to focus on PV then, and
yes, please,
and the four. Okay. So with regard to PV, first we have an unreasonable seizure, as the court has noted, and I'm going to address that one first. Section 11.
Right. Yes.
So by his own admission, PV says that the assailant, also known as AB, chased PV down, attacked him, and seized him. Not any of the Department of Health and Human Services employees, right, or employees of HHS. It was AB who, as you noted, they labeled the assailant, chased him. There's nothing in the pleadings that show a seizure even occurred by anyone related to the Department of Health and Human Services. There are no factual allegations against Department of Health and Human Services. There are no allegations of claims of policy violations or anything that the department did anything wrong as to an unreasonable seizure, as the court noted. The claim here is just frankly not appropriate to the alleged facts. Having locked doors at a psychiatric facility, that's how the plaintiffs responded to our motion. They noted that the facilities had locked doors. Well, that's not evidence unto itself of an unreasonable seizure. If it was, then
right,
you have a multitude of patients bring the claim.
Right. I don't think they're making that claim. I mean, that would be akin to arguing that they have cells and jails and prisons, and therefore there's a Fourth Amendment violation.
Right. Well, and at least that's how we interpreted their response, is that the psychiatric facility run by HHS has locked doors, and that AB or PV, PV was in this locked facility, but we argue that they have not pled anything that shows that they were seized, quote unquote, by an HHS employee. Right.
I will repair back to one of my true heroes in the law. The first person I clerked for was the Chief Judge of the Eastern District of Michigan, James Churchill. He used to refer to these as constitutional stomping cases. And he would get really angry when people would ask for dismissal, because he said they would allege in their complaint that they were standing there, that your guys chased him down and stomped him. That's a constitutional violation under the Fourth Amendment. In this case, the Michigan analog. But that's not what we have here. What we have here is some other person who's in the facility who chased him down and stomped him, right?
Right. And that person, AB, or the assailant, was not working under the direction of an HHS employee. Right. The plaintiffs have not pled that. She acted on her own. Another patient acted on her own and chased PV down, allegedly, and then allegedly assaulted him. We just see no proper pleading for an unreasonable seizure there. So moving next to the cruel or unusual punishment claim, section 16 of the state constitution. There, Your Honor, is where defendants have turned towards to federal law for some guidance. Right. Because it's unclear whether section 16 applies to psychiatric hospitals. Right. As I know, the court read, the federal courts have held that patients in psychiatric hospitals aren't entitled to claims under the or not barred, but should not make claims under the Eighth Amendment. We then due to the, I mean, frankly, there's not a lot of Michigan case law out there, and the breadth of persuasive, albeit persuasive, authority is on the federal side with the federal or with the United States Constitution. We would argue that the court should follow the United States Constitution, given its large body of Eighth Amendment claims, or case law.
And just to be clear about this, the way that the Eighth Amendment works is that if you're confined in a facility that's a detention facility, a jail, or a prison, and again, state actors inflict horrific pain on you, that can violate the Eighth Amendment because it's cruel and unusual. It's not anticipated. It's the sort of thing that's not supposed to happen to you. You can be confined, but you can't be beaten to a bloody pulp. And I think your position here is the same as the Fourth Amendment analog claim, that there's nobody who was a state actor who really did anything to inflict something that would rise to the level of cruel or unusual punishment. Now, let me ask you this, because this is the only thing that I think could survive. There are allegations, and there seems to be some photographic evidence that a couple of the people working at the facility stepped on PV's fingers when he was putting them under the door. Is it your argument that even if that happened, it wouldn't rise to the level of cruel or unusual punishment?
Yes, Your Honor. For purposes of argument, or for taking that as true, as you must for this,
sure,
for a CA argument, we would argue that yes, just bumping. I don't even know that there was necessarily stepping on fingers that would not rise to the level of a cruel or unusual type of punishment by a state actor, if the court were to interpret it as such.
Right. I mean, the chasing and the beating certainly could, but again, that's not a state actor.
That was not a state actor. That was another patient.
Right.
And here, as you just indicated earlier, we know Justice Welch's concurrence in Bowserman, whereas here, and what the court just noted, a proper avenue would be a 1983 action against any of the state actors as far as in federal court, and that would be an adequate alternative remedy than this cruel or unusual punishment under the Michigan Constitution. And again, like the court just said, there's no factual allegations here that MDHHS, like there was violation of policy or anything to do with the entity itself. And then as far as the state actors, I would agree with what the court just indicated, that stepping or nudging on some fingers does not equate to cruel or unusual punishment, Your Honor. So moving then next to the violation of due process, we both have procedural and substantive.
Right. And I'll cut you off for just a second, because I don't even know why we're talking about procedural due process. I mean, first of all, it does not fit at all. And second of all, even if it does, it doesn't really get them anywhere.
Then I won't waste the court's time, because I was just going to say that they're not alleging that they were denied some sort of hearing or anything before that.
Right, before the door was opened or some
door was opened. And they're not alleging that apparently, the HHS employees should have known something was going to happen, and they denied them some sort of relief or a hearing to get them out of the facility before that. And so I think the court is on board as far as there is no procedural due process violation regarding PV. So with that, I'll turn to the substantive argument, due process. And with here, the plaintiffs have claimed a safety and security substantive due process claim and freedom from bodily restraint as far as the due process claims.
Well, the traditional standard for something like that is it has to shock the conscience.
Correct. And here, Your Honor, again, it's the assailant or AB that chased PV down. There's nothing in the claim or in the pleadings on the face that connects this a substantive due process claim to the Department of Health and Human Services or its employees. And in fact, we brought up in our original motion for summary, well, let me strike that. In their original pleadings, they just made a general due process claim. In our motion for summary, we argued it appears to be a procedural because we didn't even interpret a potential substantive due process claim from the pleadings. It's in their response is when they first brought up, well, no, we make both a procedural and substantive. So you really have to look at plaintiff's response to our motion for summary to even try to interpret some sort of substantive due process claim. And we just do not see that as happening because again, the assailant or AB is the one that chased PV down and allegedly attacked him. There's nothing to do with the department. There's nothing to do with department personnel. At most, taking their pleadings as true, someone opened the door or someone opened a door. But there's nothing factually asserted in their pleadings that employee even knew what she was doing or had reason to know that AB was going to chase PV down when she opened the door. There's no factual allegations in the pleadings that would connect that. So
I think they say though that the people who are working there, I keep wanting to use the word guards, but guards isn't the right terminology in this setting. That the people who are working there somehow encouraged or emboldened or sent AB after PV. And again, the pleading standard is generous. I'm not suggesting that the evidence will ultimately bear that out, but we can't really look at the evidence at this point.
You're right, Your Honor. And at this point, I can't present depositional testimony or anything else. And so I just, we have to take it at its face value in the pleadings. And again, I would argue that there's nothing in the pleadings that creates or gives this court something to latch onto as far as a substantive due process claim. And so I guess with that, then that's the end of my substantive due process argument, such as it is.
Okay.
Did the court want to hear anything about the declaratory relief, or is that a non-issue as well?
Right. I just don't see where declaratory relief is of any consequence here. I don't even know what it would get the plaintiffs. I mean, I'm going to ask counsel for the plaintiffs, but I don't see declaratory relief as of any value.
Yeah, and neither do defendants, obviously, Your Honor. And so, just so I'm clear, the court would not. The court seems to be indicating that the failure to state a claim as far as AB. You don't need to hear my arguments on that because it's even less. She did these acts herself.
Right. I mean,
these are volitional acts.
Right. The only thing I'm struggling with there is whether to grant summary disposition under C8 with prejudice or without prejudice. And it just, in other words, allow them to amend or not. And I just don't, futility is a pretty generous standard for the pleader, but I can't see any way that they can plead any sort of viable constitutional violation visited upon AB.
Right. And there, Your Honor, we would obviously ask for a with prejudice dismissal, just to put that on the record. So,
okay, thank you.
If the court has no further questions, and I have nothing to add at this time.
Okay, I'm all set. Thank you very much. I appreciate it. Okay.
Thank you, Your Honor. Stacey Hamelman, appearing on behalf of the plaintiff.
Okay, well, good morning, and I'm glad to have you here. Would you mind coming up to the lectern here? I just want to make sure that we're getting the best sound quality we possibly can get.
Thank you, Your Honor. So at the outset, I think just to set the stage, to borrow a phrase from brother counsel, there's a couple of things that need to be recognized. And the first you did in terms of this is a notice pleading state.
We're not an Iqbal Twombly jurisdiction. I've said that at least 1,000 times.
Yep. We don't have to give chapter and verse.
Right.
Just enough to put them on notice as to where we're coming from. Secondarily, as part of the allegations that we've made in this complaint, both complaints for PV and AB, before getting there, we did as thorough of an investigation as we could to get a factual basis of this. In large part, it came from the video, which we received from a FOIA request.
Yes, and thank you, by the way. I was able to see the still photos that you put in the materials, and it's very helpful.
So but the one thing about that is the video that we did get, it's not the whole story. Okay, that video was edited, spliced together. There is no audio to it, presumably because of all the different cameras and they're splicing it together, the audio can't correlate. But that is in a microcosm or macrocosm, actually, all the information that we had to glean from in order to make
Well,
these
stop for just a second,
allegations.
because I'm trying to understand where you're going with this. Are you suggesting that I have to be more deferential on C8 review because you want to do some discovery and then you think you'll have more? Because it seems to me that I'm stuck with the pleading, but the pleading, at least as far as AB goes, offers me no pathway for a viable claim for a constitutional violation.
I want to see if I can change your mind on that.
Okay. I mean, with
but when I
PB,
get there.
you're going to
But-
live to fight another day. And I want to talk to you eventually about the statute as well. I'm inclined to let you amend to plead both the statute and the constitutional violation. We'll sort it out once we have some evidence. But with AB, I'm really struggling to understand how I let it go past today.
Can we start with PV first?
Well,
But
sure.
in-
Yeah. I mean, that's
okay.
by far your better
Yeah.
case.
In terms of, quick answer to your question, under C8, where the court rules don't contemplate discovery for that. But under
Sure.
C7 standard, yes, discovery is contemplated for
Well-
purposes of making a C7 decision.
Yeah, yes and no.
Yeah.
I mean, I hear what you're saying, and I don't want to prematurely rule against you under C7, but as I think you understand, I'm not looking to apply C7.
So
To me, if they win on C8. They don't win under C7. You have me on. You have me at Bowserman.
very good, very good. So, and then going to Bowserman and this adequate alternate remedy that you were referring to at the outset, parading Section 1722 of the Mental Health Code as an adequate alternate remedy is frankly a charade. And here's why. Because the Dockweiler case we cited in our brief, it's clearly stated, the Court of Appeals recognized that the principles of governmental immunity apply to this other civil remedy issue, this monetary damage claim. So yeah, we will be back at square one with the AG arguing that governmental immunity applies and bars what.
Right. I am not going to send you on a road to nowhere. I mean, they can't argue on the one hand that there's an adequate statutory remedy, and then on the other hand, turn around and argue that any claim under that statute is barred by governmental immunity. I'm not going
Right.
to have you ensnared in that trap.
So then when you consider this, consider Dockweiler that was addressing other civil remedies under 1722, the Court of Appeals clearly said there that, okay, that's governed by, or that's subject to governmental immunity. So we wouldn't, under that statute, be able to bring a monetary damage claim.
Right.
Then the only other thing is injunctive relief. And how is that a remedy? Because neither PV or AB are patients at this facility.
Well, right.
Any longer.
Right. Besides that, injunctive relief completely misses the point of this case.
The horse is out of the barn.
Right. Not to mention the fact that courts generally are not supposed to enjoin agencies. We're supposed to issue declaratory relief only because we're not supposed to be heavy-handed with other branches of government. I mean, there are lots of cases that say that, but that's the principle in the back of my mind. Injunctive relief has nothing to do with this case. You're talking about a single incident where one of your clients was injured, and what an injunction would do to remedy that is completely beyond me.
Right. So based on that, in applying that statute to the factual circumstances here, Our position is that it does not amount to an adequate alternate remedy.
Right, but let me
And-
ask you this, let me stop you for a second, because what I'm inclined to do is allow you 3 weeks leave to amend your complaint in PV to, if you want, add a claim under MCL 330.1722. But that would be in addition to a substantive due process claim. That way, you can't get stuck where you have to make a Hobson's choice.
Well, it ultimately kind of is, Your Honor, because there's really nothing available under 1722.
I tend to think you're right about that, but I don't want to rule out the possibility that it could be an adequate alternative. What I'm promising you now is, if you plead it, I'm not going to throw you out on the constitutional claim on the assumption that the statutory claim is an adequate remedy. What I want to do is arm you with both of them. So if they argue governmental immunity to block you from seeking money damages under the statute, you'll have necessarily your constitutional claim.
Understand.
Okay.
Understand.
And this is one of these where I think you have a potentially viable claim, and I'd rather have it pleaded in every way it can be pleaded, because eventually somebody upstairs is going to take a look at this. And I don't want you to get stuck arguing only the constitutional claim to be told at the Court of Appeals or the Supreme Court, you had a statute, you should have used it. And I don't want you to go exclusively on the statute and be told governmental immunity bars it. If you really wanted money damages, you should have stuck to the constitutional claim.
Gotcha. Alternative is fantastic.
Right, because that's how I size this up. I mean, the statute is only a viable alternative if it allows you a money damages remedy.
In these circumstances. Yep. Thank you, Your Honor. So I think we're on the same page there as to the holding of Bowserman and
yes,
how it may or may not relate to available relief under the mental health code.
How hard do you want to fight in PV for your Fourth Amendment style claim or your Eighth Amendment style claim? Because I just don't see those as viable. Substantive due process I see as viable.
So I do want to make I put our position on the record about this, because I do think they're viable. Because what the Attorney General does, it focuses on the facts, but very myopically.
Can I stop you for just a second?
Sure.
Because there's no doubt that the Fourth Amendment claim, Fourth Amendment style claim, and the Eighth Amendment style claim are mutually exclusive. There is no world in which you can prevail on both of those. Can we all agree on that? Because the context is, you're either effectively a free person guaranteed protection against unreasonable searches and seizures, or you're a detained person who is provided with protection against cruel or unusual punishment. I mean, the federal courts have been really, really clear about that. And the question is whether it's a Fourth Amendment case or an Eighth Amendment case, but in no world can it be both.
So what's interesting is, as we were looking through this, our constitutional provision varies from the federal courts in that it's cruel and unusual versus, where our courts have said, yes, we interpret it more broadly, but one or the other.
I agree with you on that, but it's the context in which the claim that arises that determines whether it's an unreasonable search and seizure claim or a cruel or unusual punishment claim.
Sure. And what's interesting is these psychiatric facility cases, they're kind of a gray area. You know, it's not a corrections facility, but there is some limitation in movement and what goes on in there. But one or the other, I think, whether they're mutually exclusive or not, and we can plead in the alternative, certainly.
Sure, right. I'm not suggesting you can't. It's an odd distinction to have to draw, though, because you're essentially saying we don't know whether the person was in custody or free, which is really the distinction between the two claims.
Well, so here's our point on our constitutional provision, section 11, the unreasonable seizure. And this is where it's not just locked doors and unlocked doors in a facility. looking at the context, is defendant's employees chose to unlock one door and let AB into PV's unit. Okay, they did it, and we've alleged in our complaint at paragraphs 38 and 39 that that the employees knew she was agitated. They knew she intended to cause him harm, and they unlocked the door and let her in.
Okay,
Then-
so just to be clear, then, what you're saying is the distinction between this case and a case where the guards let a serial killer into somebody else's cell, knowing the serial killer has a knife, is not one of kind, it's just one of degree. In other words, it's the same sort of claim. I think you have a perfectly viable claim for an Eighth Amendment violation if the guards had had a dust up with somebody who's an inmate at a prison, and as a result of that, they let a serial killer carrying a knife go after the person. I mean,
So
even though the damage isn't visited directly by the government officials, that's enough to get you there.
and that's it, because they used AB here, the defendant's employees used AB as their means by which to, well, for Eighth Amendment, inflict punishment on PV, because PV had been sticking his fingers under this door for a while and potentially was irritating the workers there, the daily workers.
Mhm.
And so then after they step on his fingers, like he keeps doing it, so okay, let's bring in AB and we'll have her then take care of the problem. And then so to go back to this unreasonable seizure piece, once they chose to let her in that unit, which she otherwise never would have had access to or should have had access to, they kept the other door locked. And that's the door that PV wound up against as she was stomping on it. So by virtue of unlocking one door, keeping his avenue of escape locked, that is a reasonable or unreasonable seizure. He had nowhere to go. And he was dependent on these people, the workers, for like unlocking, locking, and his freedom of movement. So it's not just AB and what she did, it's AB's action set in motion by defendant's employees, knowing, as we alleged in our complaint, that she intended to cause him harm.
Okay.
Yeah. So,
You
and then-
want to talk about AB, because I can't see any way I let that go forward.
if I could, yep, for one more minute, talk about the
You're in good shape on PV.
on PV. Okay. I hear you. So, and I guess AB looking at cruel and unusual punishment for AB.
How was she
Okay.
punished in any way?
Okay, no definition of punishment limits it to corporal punishment. Okay, it's and what they did and what we've alleged is they've used her as the enforcer of the facility's rules and regulations. They orchestrated this physical confrontation between her and PV.
There's no indication whatsoever that she was anything other than the aggressor or that she was injured in any way. I mean, she stomped him.
Not physically injured. But don't forget, Your Honor, she's there for mental health treatment. And then as we've alleged, and this is in the complaint against the individual defendants, but we've alleged there, one of the employees goes right into her room afterwards and berates her for having participated in this when they put her up to it. So, and I'm curious because,
Are you saying the berating rises to the level of a constitutional violation?
considering it in the context of everything else, it's part of this cruel and unusual punishment for a patient
If
who's.
you're right about that, you know how many prisoners have claims under the Eighth Amendment, or state prisoners have claims under the state analog? I mean, do you know how often guards scream at prisoners?
Well, okay, if there's that many, it's shocking to me that this kind of conduct that we have here is occurring elsewhere in our facilities. Okay?
No, but
Like,
you
this
just
is-
said the
no,
berating is a constitutional violation.
what I said is in the context of everything else, because they put this in motion, they put her up to it. And so for a person who's at this facility for mental health treatment, I'm doing what you tell me, and then now I'm being, punished. And so I'm kind of curious to see how the AG would categorize what occurred here. Because if not punishment, it's certainly not mental health treatment.
Well, I would agree with you if, for example, she was put in isolation for 60 days or something like that, then at least you've got something that looks like punishment.
And that's the thing, we don't have all the records because yep.
Understand.
So we've made the allegations, under our notice pleading standards. And,
But I mean,
these cases-
you're the one who chose the term assailant for AB.
at the time, I can tell you, we had no contact or communication with AB at the time. That came later. And the one thing is, and this comes across with other of the AG's arguments, like labels are one thing, like we're not governed by labels. What's a substance? And that's what our courts say.
Well, substantive due process can't be everything under the sun. I mean, it is already such an amorphous claim that people try to use it for anything and everything, and the courts have become pretty concerned about that.
And here's where it gets very interesting, and I think sets the stage for a cause of action here. Not only do you have the employee who actually opened the door, you have other of the state's employees watching what's going on, hearing what's going on, hearing AB threaten PV through the door. Nobody intervenes. Nobody does anything. And it happens. So Bowserman has set an unusual stage, it's very new. It opened the doors to these sorts of claims because.
Well, what it did was it opened the door to claims for monetary damages
Sure.
for direct constitutional violations, but it didn't change the structure of what violates the Fourth Amendment or the state analog, what violates the Eighth Amendment or the state analog, what violates the 14th Amendment or the state analog.
Well, in having, I guess, more option for litigants to assert constitutional violations. So yeah, there is not a lot of case law at this point on it. And we are embarking on a new territory. But due process is broad. But here, when you've got the employee who opens the door in front of everybody else who sees what's going on and they don't lift a finger, and so it's equally as detrimental to AB mentally as it is to PV physically. So,
I think you've covered it all, because as I said, you really don't have to worry about C7. I'm not going to throw anything out under C7.
okay.
In my mind, you easily get over C7 because of Bowserman, and the question is whether you survive C8.
So to that point, Your Honor, I would ask, to the extent that anything is dismissed, we be given an opportunity to amend the complaint. And that's because, we did as much groundwork as we could on our own with the tools we had before filing suit. So yeah, we don't have policies, procedures, that sort of thing
Sure.
that ordinarily you'd have to cite to pre-Bowserman, right, to bring a constitutional claim.
Right. Well, just to be clear, I mean, I think the Supreme Court majority said that you don't need to show a policy or procedure. That was
right.
That was the old standard from Smith. Well, to the extent anything
Right.
came from Smith, that seems to be one of the takeaways.
And so what we have is, with the limited information we could garner on our own pre-suit, Yeah, we've asserted claims. We believe we've met the standard to get past C8 and as part of notice pleading and as part of keeping up with our ethical duty under 1.109. So
You can't plead what you don't know.
right. So to that end, Your Honor, again, we'd ask for an opportunity to amend if any piece is dismissed under C8.
Okay, thank you very much.
Thank you.
Briefly, I'll give you one more round each briefly, but I'm trying to do as much as I can for the bench, so I need some time to rule before we get to the next ones.
Thank you, Your Honor, and I'll be brief, because I just want to touch upon the section 11 unreasonable seizure argument, because that seemed to be the one that the court was maybe most, sorry, the one that the court, aside from, well, the substantive due process, the court has already kind of tipped its hand that very well may survive per Bauserman, and the plaintiffs will get an opportunity to amend and make that argument. But I just want to touch upon the unreasonable seizure because we still would argue that should not survive.
Right. I tend to agree.
Okay. And so let me, if I may just hit a couple points here, Your Honor. The plaintiffs said first that an employee chose to unlock a door. Well, so and unlocking of a door does not seize a person, that opens an avenue.
Sure.
And they allege that the employees knew that AB was agitated and that they used AB as a means to inflict punishment. Again, I guess this court has to take those assertions as true for purposes of a C8 motion. But they then said that the employees chose to let AB into the unit and kept the other door locked, and that was then an unreasonable seizure. I guess two things, Your Honor. The nature of a psychiatric facility, I think the court could take notice that there are locked doors, there are unlocked doors.
Sure.
It's not totally akin to a prison, but if there are people that are involuntarily held at a psychiatric facility, one is not going to be able to be free to come and go as they please.
Right. So
I guess I want to make that point. There are going to be some locked doors and some unlocked doors, just as the nature of, well, this building, there are locked doors and unlocked doors, let alone a psychiatric facility. Then B, Your Honor, there's nothing in the pleadings to show that any of the workers kept that second door that they allege AB was unable to open and thus unreasonably seized him. There's nothing in the pleadings to show that the employees locked that door beforehand or kept it locked or anything. Those are things outside of the pleadings as far as I can tell, Your Honor. So I'm struggling, as I think the court is as well, with how was AB, strike that, how was PV, unreasonably seized in a psychiatric hospital. So I just want to put that on the record, Your Honor, and thank you.
okay, thank you. Any final words? I think I have my arms around this one.
The only point, Your Honor, is that these units, like AB, was intentionally separated.
Oh,
from
yes,
PV.
yes, right. It's adolescence
And-
and youth.
Yeah, 10-year-old from a 15-year-old,
Right.
and from what we understand too, boys from girls. But the letting her in, as you alluded to, letting another inmate into a jail cell. That's what this is. So unless you have any questions, Your Honor, I have nothing further.
No, thank you. All right, let me get a book here and then I'll take care of this. Sorry, threw my back out. It's been one of those things. Okay, let's start from the top. In the verified amended complaint in 40-MM, the PV matter, the claims stated are as follows. Get there. Count 1, unreasonable seizure in violation of the Michigan Constitution of 1963, Article 1, Section 11. In count 2, infliction of cruel and unusual punishment in violation of the Constitution of 1963, Article 1, Section 16. And it's actually more generous than that. It's cruel or unusual punishment. And count 3, deprivation of due process in violation of the Constitution of 1963, Article 1, Section 17. So those are the 3 constitutional claims asserted on behalf of PV. In the AB case, if my memory serves me correctly, there are only 2 claims. First, count 1, infliction of cruel and unusual punishment in violation of the Constitution of 1963, Article 1, Section 16. And as I already said, that could be cruel or unusual punishment. And then count 2, deprivation of due process in violation of the Constitution of 1963, Article 1, Section 17. So let's talk first about the request for summary disposition by the defendant in each one of these cases under MCR 2.116C7 based upon governmental immunity. The argument by the defendant would be far more persuasive under C7 were it not for the decision of the Michigan Supreme Court in Bauserman 509 Mich 673. I'm going to read a couple of passages that I think make a great deal of difference in our case. First of all, at 509 Mich at 687, the Supreme Court said, quote, money damages are an available remedy for constitutional torts unless 1, the Constitution has delegated to another branch of government the obligation to enforce the constitutional right at issue. And we can all agree that all 3 of the rights here invoked in the complaints are not categorized that way. Or 2, another branch of government has provided a remedy that we consider adequate. And that's what we're talking about here. Bauserman makes another important point with regard to C7 at 509 Mich at 688, where it notes, quote, in talking about the Smith case, it notes, quote, 4 justices agreed that governmental immunity was not a defense to allegations of constitutional torts and that damages may be recognized in appropriate cases. Moving on to 509 Mich at 689, there's a discussion of Justice Boyle's concurring opinion where there's a much more detailed discussion about immunity. Quote, she would have remanded plaintiff Smith's case, writing separately to emphasize the allegations of state constitutional torts avoid governmental immunity. She opined, quote, it is so basic as to require no citation that the Constitution is the fundamental law to which all other laws must conform. With regard to statutory governmental immunity, she noted that all statutes should be construed to avoid constitutional invalidity. She concluded, quote, the idea that our legislature would indirectly seek to approve acts of the state which violate the state constitution by cloaking such behavior with statutory immunity is too far-fetched to infer from the statute. I could not agree more. It cannot be the case that a direct violation of the Constitution, if established, which carries with it a money damages remedy, could be barred by the Governmental Tort Liability Act or any other statutory provision. You cannot use a statute to override a constitutional right. And so, as far as I'm concerned, the outcome of the C7 motion turns entirely upon whether, quote, another branch of government has provided a remedy that we consider adequate. In that circumstance, then you don't have to worry about allowing a money damages claim under the Constitution itself because there's an adequate statutory basis. Which brings me back around to my view that it cannot be the case that there's a statute that provides a remedy, but the remedy of money damages is barred by governmental immunity. Now, the suggestion here is that MCL 330.1722, which states that a recipient of mental health services who is abused or neglected has a right to pursue injunctive and other appropriate civil relief, close quote. Now, it may very well be that MCL 330.1722 is the sort of statute that meets the Bauserman requirement, But I would only accept that as an alternative to a direct action under the Constitution if a claim under MCL 330.1722 is not barred by governmental immunity. In other words, it can't be the case that it's an adequate substitute for a constitutional claim if it's barred and you can't recover money damages. So what I'm inclined to do here is to deny summary disposition to the defendant in each one of the cases under MCR 2.116C7, because at least at the moment, I can't figure out whether the defendant is going to take the position if a statutory claim is pleaded under MCL 330.1722, that claim is nonetheless barred by governmental immunity. So what I'm going to do in the case of PV, I'm going to grant 3 weeks leave to file an amended complaint. And I guess in this case, it would be a second amended complaint, pleading in the alternative a constitutional claim or claims, and we'll talk about that in just a minute, and a claim under the statute MCL 330.1722. And so I'm open to a future argument for summary disposition under C7, but the record is not clear enough yet for me to determine whether, as a matter of fact, in this case, the statutory claim is an adequate substitute for a constitutional claim. That will remain to be seen once we see how the defendant reacts to the amended complaint in the case of PV. So that takes care of the C7 argument in the case of PV. What about the case of AB? For the same reasons, I believe that I have to deny the motion for summary disposition under MCR 2.116C7 in the AB case under Bowserman. Again, if AB has a constitutional claim to assert, that is permissible under Bowserman, and it may be used to seek money damages. It may be that a claim under MCL 330.1722 is also available to AB, but it's not an adequate substitute for a direct constitutional claim unless a claim for money damages under the statute is not foreclosed by governmental immunity. All of that, again, comes back to the proposition from Bowserman, 509 Mich at 687, that there is no direct constitutional claim if, quote, another branch of government is provided a remedy that we consider adequate. And I do not consider it adequate to point to a statute, to have the plaintiff file a claim under the statute, and then to have the defendant turn around and argue that a claim for money damages is foreclosed by the Governmental Tort Liability Act. So that takes care of the C7 motion in each one of the two cases. Let's move on to the C8 motion, because I think that is the harder issue to deal with in the case of PV, and by far the much easier issue to deal with in the case of AB. Let's talk about C8 analysis first. In the case of El Khalil versus Oakwood Healthcare, Inc., 504 Mich 152 at 159, a 2019 case, the unanimous Supreme Court stated as follows about motions under C8, quote, a motion under MCR 2.116C8 tests the legal sufficiency of a claim based on the factual allegations in the complaint. Moving on to 504 Mich at 160, the court continued, quote, when considering such a motion, a trial court must accept all factual allegations as true, deciding the motion on the pleadings alone. A motion under MCR 2.116C8 may only be granted when a claim is so clearly unenforceable that no factual development could possibly justify recovery, close quote. And I'll add to that the observation I made along the way that this is not an Iqbal Twombly pleading jurisdiction. You don't have to allege all the facts in excruciating detail and essentially establish as a matter of pleading exactly what your claim is and why it's so viable. All you really have to do is plead enough to suggest that a viable claim may exist and there's a reason to go forward with discovery, and then ultimately consideration under MCR 2.116C10 to test the factual sufficiency of the claim, and if it survives C10 to go to trial. So let's start with the case of PV. As I indicated, there are 3 claims here under the Michigan Constitution. The first one is an unreasonable search or seizure claim under Article 1, Section 11. Of course, it'd have to be a seizure because this is a physical attack. Second, under count 2, the allegation is one of cruel or unusual punishment under Article 1, Section 16 of the Constitution. And then finally, in count 3, there's a claim for deprivation of due process in violation of the Constitution, Article 1, Section 17. I find, as a matter of fact, that there is no basis for a claim of unreasonable seizure, nor is there any basis for a claim for infliction of cruel or unusual punishment, because quite simply, the allegations in the complaint, taken as true and in the light most favorable to the plaintiff, do not establish that any employee or officer of the defendant engaged in anything that could be described as an unreasonable seizure or cruel or unusual punishment. The very most you have is the allegation that 1 or 2 of the workers at the facility at the outset of this confrontation stepped on the fingers of PV. But if you read the complaint, it's clear that the fundamental constitutional violation here rests upon the fact, or at least the allegation, that AB was allowed to attack PV. And I just don't see how that rises to the level of a violation of Section 11, because I don't see it as a seizure by any employee or officer of the defendant, or how it rises to the level of cruel or unusual punishment, because again, it simply was the case that a door was opened and AB was allowed to cross over into the other part of the facility where the attack then occurred. I reach a different conclusion with regard to the claim for a due process violation under Article 1, Section 17. There, I grant summary disposition to the defendant with regard to the claim of procedural due process. There's just nothing here that constitutes a procedural due process violation, nor could there ever be. But I'm going to allow the plaintiff, in this case, PV, to proceed on a claim of substantive due process. So with regard to the case against PV, I'm granting you 3 weeks leave to amend. You may assert 2 claims if you wish. 1, a direct constitutional claim for a substantive due process violation, and 2, a claim for a violation of MCL 330.1722. I'm not trying to put you on the horns of a dilemma, quite the opposite. I'm trying to make sure that you have some avenue to seek redress here, whether it's by statute or by constitutional claim. I think you have enough in the PV case to go forward, and I'm going to allow you to do so. All right, let's move on then to the case of AB. Here, as I indicated earlier when we were discussing it, there are only 2 claims, not 3. The first is a claim for infliction of cruel or unusual punishment in violation of Article 1, Section 16 of the Constitution. In count 2, there's a claim for deprivation of due process under Article 1, Section 17 of the Constitution. I find no basis whatsoever for a claim to go forward for cruel or unusual punishment. Even the pleadings submitted by the plaintiffs themselves refer to AB as the assailant. I've heard some discussion today that perhaps the fact that AB was berated after this happened caused mental anguish. That doesn't even come close to meeting the standard of cruel or unusual punishment. Similarly, I find no basis whatsoever for a claim of a deprivation of either procedural or substantive due process. Procedural due process, as I say, doesn't even apply in the case of PV, and it certainly doesn't apply in the case of AB. And then with regard to substantive due process, typically you need conduct that shocks the conscience. That's the old test from Rochin, R-O-C-H-I-N, from the US Supreme Court. As I say, substantive due process is a really amorphous claim. It can be anything or nothing at all. There's some great scholarship on how difficult it is to pin down a claim for substantive due process, but essentially you need governmental conduct that is outrageous to a rather significant degree. And I don't find that anything done to AB even approximates that standard. Therefore, under MCR 2.116 I-5, I am going to deny leave to appeal in the case of AB because I find that it would be futile. The general rule stated in MCR 2.116 I-5 is as follows. If summary disposition is granted under subrule C8 or C9 or C10, quote, the court shall give the parties an opportunity to amend their pleadings as provided by MCR 2.118 unless the evidence then before the court shows that amendment would not be justified. An amendment would not be justified if it would be futile. I find the futility standard, although high, has been met in the case of AB, and therefore I believe that this ends the case with regard to AB. I do not find any viable constitutional or statutory claims that could exist in this case. So let's then move on to the trickier questions in the next two cases. And let me pull those up, swap out my papers here. I'm going to talk about these now. One of the complicating factors of suing state officers, agents, or agencies is that once upon a time, if you followed the logic from published Court of Appeals opinions, you were able to commence litigation in a circuit court for certain claims. And you didn't have to worry so much about compliance with the notice and verification requirements. That all changed last summer when the Supreme Court unanimously held that the notice and verification requirements apply even if you initiate litigation against state officers or employees or agencies in a circuit court. Here, at least as far as I can tell, the cases that came to the Court of Claims were both initiated in the Wayne County Circuit Court. The PV case named a whole host of defendants, and I want to start by cleaning up some loose ends on this one, and then we'll do the same thing in the case involving AB. I think where we are here is that we've reached an agreement that the claims against some of these defendants can continue in the Wayne County Circuit Court. Is that correct?
Your Honor, yes, correct. At this time, the defendants that remain in Wayne County, in the Wayne County Circuit Court, are not represented by the Department of Attorney General.
All right. And so, at least as far as I can tell, the plaintiff's objection to the notice of transfer is well taken in each one of the cases. Do you agree with that? Because the objection to the notice of transfer dealt with the fact that the entire cases were to be transferred. Now, I know that there was then an amended notice of transfer that was filed. So I think your position is the amended notice of transfer reflects reality.
That is absolutely correct, Your Honor. That was an error on our part. We should have made it more clear.
Right. No, I'm not here to criticize anybody. I just want to make sure that we know where we are. Okay. From the plaintiff's perspective, then, do you accept that the amended notice of transfer in each case is now correct and you can proceed in the Wayne County Circuit Court with regard to about half of the defendants?
Your Honor, we believe that the amended notice of transfer specifically identifying
Right. I forget where the line of division is exactly. I think it runs down through the officials, and it doesn't include the people who are actually on the ground when the
Correct.
incident occurred.
So it would be the individuals up to or up through Jennifer DeLong
All right.
on each caption.
All right. That's fair. So then the other ones, Bria Howell, Kentoya White, Shannon Mixon-Bird, Joy Gillenkirk, Delisha Montgomery, Tremaine Butler, and then the Jane and John Doe defendants are still in the Wayne County Circuit Court, and that is appropriate in your view.
Correct, Your Honor.
The other ones are here in the Court of Claims, and you agree the other ones belong in the Court of Claims, everybody down through Jennifer DeLong?
We understand that the AG appropriately removed it.
Okay, fantastic, great. So that takes care then of the notice of transfer in each case. And I take it, there's nothing I need to say in an order at this point?
I do not believe you need to, Your Honor. I just want to, for the record, state that the defendants that still remain in Wayne County, my office does not currently represent them.
Okay.
But that could be subject to change. I
Okay.
can't predict the future. So I just want to let you know that
Okay.
as of today, we represent the defendants Mellos, DeRose, Solke, Petty, Glenn, DeLong, and then also defendant Coleman in the AB case.
Okay, that's fair. So I will do nothing now with that. I'll leave that alone. Now, let me just stop for a moment on the orders to show cause. I will be the first to confess two things. First of all, the two Supreme Court cases that came down really surprised all of us on the Court of Appeals, and it created a heck of a dilemma for an awful lot of people who relied on published Court of Appeals opinions. But it's the law, and we can't change it. I mean, it is what it is. The second thing I'll say, because I feel like the plaintiffs took umbrage at the issuance of the orders to show cause, I don't mean to suggest that I sit around looking for reasons to throw cases out. We're just trying to get these issues cleaned up and aired out before we send the case upstairs to the Court of Appeals and then on to the Supreme Court. So I think I'm satisfied that these two cases belong here. And they don't have any of those procedural defects, but let me give each side an opportunity to weigh in, because it is so tricky right now to figure out how this applies. So.
Thank you, Your Honor. With regard to the Court of Claims Act, we raised first in our brief as far as AB that she did not plead timely. And I want to address that briefly because this falls under the Court of Claims Act.
Right.
We argued it was some 2-3 weeks tardy for the 6-month window to file properly, or timely rather, under the Court of Claims Act.
Okay, so
we made that argument before the court sua sponte made your the verified complaint question or show cause. So AB responded to our timeliness argument that they filed the other case, the M against the department, and that somehow counted for notice on their AB versus Mellos et al. Case.
Right. And so when you say that, you're not talking about PV now. You're talking about the Court of Claims original action that was filed against the department.
Correct. That's the AB, and this is tricky because we're dealing with 4 cases, so I'm going to try to make it clear.
That's why I'm trying to be really precise.
Yes. We are not arguing the timeliness of PV versus Mellos et al. We are arguing the timeliness solely of AB versus Mellos et al.
Okay.
And in response to that argument, AB argued that their other case, AB versus MDHHS, somehow counted as giving the court notice under the statute. That's without merit, Your Honor. There are different cases, different claims, different parties, and therefore AB versus HHS does not give this court notice under the Court of Claims Act. And for that reason alone, AB versus Mellos et al. Should be dismissed by this court.
Okay, but you're not making the same argument with regard to PV.
No, we do not make the timeliness argument with regard to PV.
All right, let me just take a quick look and make sure I've got the right piles here, because I'm gonna go back and take a look at this. So the PV case is one where you believe the order to show cause is not well-founded.
No, Your Honor. I haven't addressed the order to show cause yet. I just wanted to,
Oh, you're talking about your own argument.
my own argument, I just wanted to get that because we also made a court of claims argument. And so I thought it would be appropriate now to discuss that before I got to the show cause. And I'm sorry for the confusion, but
No, that's okay.
I thought since we're talking about the Court of Claims Act, that I would include discussion of that since we made that argument solely as to AB.
Okay, so talk to me about PV. What's your
Yes, sir.
view on the show cause order?
With regard to the show cause order, we agree, and well, I guess the court brought it up. We agree that both PV and AB failed to file the notice and verification required as to the official capacity claims. I guess I want to make that clear, Your Honor, because we have official capacity claims and we have individual capacity claims. So as to the official capacity claims, both PV and AB failed to give the notice and verification requirements as required against these executive defendants whom my office represents.
All right, so just to be clear then, you're saying their official capacity claims should be gone, but not their individual capacity claims.
Correct, Your Honor. And our rationale is threefold. State officials acting in their official capacity claims, or in their official capacity, are essentially the state, and that's under Will versus Department of State Police.
Yep.
So the official capacity claims against our executive defendants, whom we represent, are claims against the state, and thus the Court of Claims Act applies. Also, if the plaintiffs have to abide by the Court of Claims Act and abide by the provisions in the circuit court per Christie, as the court just alluded to, and further, the Elliott case precludes them from going back and amending their claim at this point. So
It's too late.
Correct, Your Honor. So in sum, both of these cases should be dismissed for failure to follow the Court of Claims Act, both due to lack of being a verified complaint as to the official capacity claims. And then in Bonter, we would argue that it should be dismissed both as untimely in whole, both individual and official capacity. And then also for the timeliness that the issue that the court brought up.
Right. So if I agree with you, the AB case against the individuals completely goes away.
Yes, sir.
The PV case against the individuals would then be limited to claims against all of these officers, whatever you want to call them, in their official capacity, but not in their individual capacity.
Opposite way around.
Oh, I'm sorry. I may have lost myself on my own construction of a very bad sentence. So what would remain then in 71-MB would be the individual capacity claims, but not the official capacity claims.
Yes, Your Honor.
Okay, sorry. I talked myself right around into a circle and I screwed it all up. Okay, I got it.
That's our stance, Your Honor,
Okay.
as far as the show cause and the Court of Claims Act.
Okay. Anything that you want to say about those positions? I'm going to go back and take a look at this.
Yes, Your Honor. In preparing for the hearing today, beyond what's contained in our show cause response, we did find a case, and I have copies here, it's published from the Court of Appeals, 2019 Pike versus Northern Michigan University.
Hey, just give me the site, please.
Oh, sure. It is 327 Mich App 683. And it's a 2019 case.
Okay.
If you like, I have a copy here.
Oh, that's okay.
Okay.
I promise. I'm not going to decide these next two motions from the bench. There's just too much here to deal with. I'm
Okay.
going to have to sort it all out. And I promise I'll go back and read this.
So and the point is, in this case, the Court of Appeals specifically stated that the requirements under 6431 do not apply to state employees at all,
In their individual
Period.
capacity, their official capacity, or both?
at all, period.
At all, okay.
And this case, actually, the Attorney General recognized the, not Attorney Rothenberg, but the Attorney General's office recognized the authority of Pike in Progress, Michigan versus the AG. And that's a Supreme Court case of 506 Mich 74. And that's from 2020.
Okay,
So-
that's fine. I promise two things. I'm not gunning to kick people out of court on any technicality I can find. I want to faithfully apply the law, and the Supreme Court's been very clear now that we have to honor these jurisdictional requirements. But if there's a basis to keep this around, I would much prefer to keep it around. I already indicated, I think PV may have some claims here, and so
Oh,
we'll talk about the
certainly.
merits in just a moment.
Certainly, but, but as to that point, though, the complaint that was removed, it itself is not verified, and section 6434 does require verified pleadings. 6434 is not connected, that requirement is not connected with 6431
Right. Well,
separately.
how did you clean up verification, by the way? I presume it's cleaned up in some way.
The state complaint?
Yes.
The state complaints, well, the verification is the complaint against the DHHS in Bonter, so that would be under case number 53.
But PV.
PV.
Are we still proceeding on the first amended complaint and jury demand filed in Wayne County and assigned to Judge Haggerty?
Yes,
All right, so no new pleading has been filed since you arrived in the Court of Claims.
correct.
Okay.
Not in state court.
Okay, I got it. Right. And
Yep.
you obviously had some first complaint, and this is an amended complaint.
Right. So, but to be here in the Court of Claims, we do need a verified complaint. So I'd ask an opportunity to amend it to the extent that we get that's what's here.
And you're not going to be
Verified.
out of time if you do that?
No, because the time requirement under 6434 is separate from,
Okay, all right.
so basically, we just have to do it within the period of limitations.
All right, so I'm not looking to resolve that for once and for all from the bench today. Let me go back and take a look at that, and I'll see what I can do. I'll do the best I can with it.
And actually, Your Honor, if I could, yeah, and I gave you the Progress Michigan
Yep.
site, correct?
Yes.
Because that's the case where the Supreme Court indicated that 6434 is entirely separate
Yep.
from what's the timing requirement under 6431.
All right, before we get going on the motions for summary disposition, then can you help me with one more question I have? The Wayne County case initiated by AB appears to still be proceeding on the original complaint and jury demand. Is that correct? Am I right about that?
Correct. That complaint has not been amended.
Okay.
Yep.
The last thing I want to do is go through C8 analysis and have the wrong pleading.
Right,
Right,
right.
so I don't mean to sound dense, but just to be clear,
No, there's a
PV
lot going on.
PV is on the first amended complaint from Wayne County,
Correct,
and AB is on the original complaint from Wayne County.
correct.
Okay, great. Now let's get to the motions for summary disposition. And I promise when you get a ruling, you're going to get a ruling across the board on all this, but this is far more of a lift than I want to try to do from the bench on these two. Okay. Get this out of the way here. I just have to make sure that I've dealt with everything that I meant to bring up. And I think I'm just about there now. Great. So let's turn to summary disposition in these two cases. Let me start out by just saying a few things about them. In the PV case, going back to the first amended complaint filed in the Wayne County Circuit Court, if I recall, there are 5 claims. I might be wrong, but I think I'm not. Intentional infliction of emotional distress against the direct care employees. And I suppose, at least for the moment, we don't have to worry about that because they're not here. So that's out. Count 2 is the Child Protection Act against the direct care employees. Once again, they're not in front of me, so that's out. Count 3, gross negligence against the direct care employees. Again, out. Count 4, gross negligence against the executive defendants, and that is very much in play, and we'll have to talk about that. And then finally, count 5, false imprisonment against the direct care employees, and that's out because, again, the direct care employees are not here. Everybody agree with me so far?
Yes, Your Honor.
Good. So we have one claim in the PV case, and that's gross negligence against the executive defendants. And then moving on to the AB original complaint from Wayne County. My recollection is that there are not as many claims here, but I want to make sure that count 1, intentional infliction of emotional distress against the direct care employees, is out because I don't have them. Count 2, violation of the Michigan Child Protection Law against the direct care employees, out because I don't have them. Count 3, gross negligence against the direct care employees, out because I don't have them. Count 4, gross negligence against the executive defendants, again, very much in play. And that's it. So this is as simple as it gets. We have to consider on review under both C7 and C8 whether this gross negligence claim against the executive defendants in each one of the complaints can survive analysis under C7 and C8. Now, I think if you allege gross negligence, you're in compliance with the GTLA, but you still have to be able to allege and prove gross negligence. Is that the basic point?
I would agree, Your Honor.
Okay, so to the extent that you argued C7 in here, my recollection is your argument had to do with among other things, the fact that there were these jurisdictional defects, or was it just straight up GTLA?
Straight up GTLA, Your Honor. Both the defendant's actions were not grossly negligent, nor were the proximate cause.
Okay, so simple enough then. This comes down to the same basic gross negligence analysis that I've had to do countless times before. Okay,
Right.
so let's keep it relatively simple here because I think I get this argument. I'm not ready to decide it from the bench, but I know you're going to tell me gross negligence is a very high standard.
Correct, Your Honor. So we're just down to the gross negligence and the proximate cause, 2 issues.
Right.
PV, and I'll address PV first and AB second. Yep. So PV's arguments are that the executive defendants somehow acted in concert, contributed to a toxic environment at the Hawthorne Center, that they groomed or permitted to exist this culture at the Hawthorne Center, and that the executive and that the employees there believed they could get away with anything, with virtually anything, and that the that the executive defendants had duties of care toward PV to prevent the alleged attack, provide safety, etc. And then last, that the executive defendants failed to assist the Michigan State Police with an investigation.
Right. And
so, I'm sorry.
No, I expect you're going to tell me that they're 2 steps removed. And by 2 steps removed, I mean, first you've got AB, and then second, you've got the people on the ground.
Yes, Your Honor. In some, though, these are all conclusory allegations.
Oh, okay.
I want to.
Sorry, I didn't mean to cut you off at the threshold.
No, these are just conclusory allegations that there are no specific evidentiary proofs given by plaintiffs that the defendants created this toxic culture where the employees at the Hawthorne Center could get away with anything, These are just, as the court alluded to earlier, amorphous terms, amorphous allegations that should not survive a CA or a motion.
Right, because I've had several of these cases as a judge on the Court of Appeals, and the difficulty when you say that you can avoid immunity by pleading gross negligence is everybody just says gross negligence again and again and again, but you need to plead facts establishing that it's something more than routine garden variety negligence. And it seems that's where the real struggle is, just getting somebody to plead it in the first place, much less to prove it.
And I would agree with the court there, Your Honor. Here, the pleadings onto the on their face, they don't even plead a negligence. Well, they may plead a negligence, but gross negligence to our defendants, who are executive defendants, who the most that plaintiff's complaint could possibly be read as is that they somehow created this culture at the Hawthorne Center and had something to do with it. Well, we would argue, even if that's true, which the court would have to accept as true, we would argue that's not gross negligence.
Well, let me ask you this, because this is why I jump to the areas where I find the greatest weakness that can end the claims now. One of the things I expect they're going to say is under C7, you can consider materials beyond the pleadings. This isn't the C8 analysis. And as a result of that, we need discovery before we can make a final decision about what all these executive level people did. Now, I tend to understand and be sympathetic with your view that you can dig as far as you want. You're not going to find anything here that's going to rise to the level of gross negligence. But at least in a procedural perspective, it's not an unreasonable argument to make that they ought to be allowed to do some discovery before I knock them out on lack of gross negligence. That's why I jumped to the other ones, because it seems to me that if you get to this argument that it's not the proximate cause, I don't know how you could argue that the executive defendants were the proximate cause of anything that happened that day.
Which you went to where I was going to go next. Obviously.
Okay, let's talk about that, because I think that I feel more comfortable talking about that, because we really know the facts we need to know for that.
Sure. And to your point, Your Honor, as to first, I'll stick with PV. They have not pled anything to show that the defendants, these executive level defendants, not even at the facility that day, were the proximate cause of any of PV's alleged injuries. They haven't proved that the defendants were involved in any way. To the contrary, AB, whom they label as the assailant, and possibly to a lesser degree, defendant Howell herself, right. They were the proximate cause of any injuries, not some supposed culture created by the defendants, allegedly created by the defendants. Right,
because you essentially have, even if you accept everything that they allege is true, you have these concentric circles of responsibility. AB's at the center, then the people who are on the ground, then at best out to the third circle to pick up the executive defendants.
Yes, Your Honor, and accepting as true that defendant Howell unlocked the door and allowed AB in, PV's alleged injuries were foreseeable only to AB herself and possibly, for the sake of argument, defendant Howell. That's it. Our defendants, the executive defendants, are neither the factual nor the legal cause regarding their alleged actions. And under Ray, you need both. You need both the factual and legal. And here we can't get past the factual, and therefore the court does not even, frankly, need to analyze the legal cause. So they argue that there's proof of that there's video cameras. That was their retort or response rather to our motion. But there's no proof, Your Honor, that the Hawthorne Center employees knew about these cameras, or somehow that the executive defendants reviewed these cameras. There's nothing in the pleadings that indicates that. I just would repeat that the proximate cause was AB, and possibly defendant Howell herself. Those two people are these executive defendants were not even a proximate cause, let alone the proximate cause, and that's what the court obviously needs to focus on.
That's
So
here's that particular analysis is exactly the way I was trying to reason this one out, because that language of the proximate cause is such a tough standard for plaintiffs to meet.
yes, thank you, Your Honor. Would you like me to address AB in the same manner, or
Sure.
because I mean, since we're
Sure.
it's kind of stick along the same lines. Again, and some of my arguments are obviously repetitive because their claims are repetitive. As to AB and the gross negligence claim, they make some of the same claims that the executive defendants groomed or permitted this culture at the Hawthorne Center and allowed these actions to occur with impunity, and that our executive defendants had a duty to provide them with care. Again, these are conclusory allegations. Now, this is just to arguing that the actions themselves were not grossly negligent. My arguments are the same, Your Honor, that these are conclusory allegations that do not demonstrate that a substantial lack of concern for whether an injury results, the gross negligence defined, that's not even there. But as the court's already indicated, the second aspect, the proximate cause, as to AB herself, AB was the proximate cause of her own injuries. I don't know how the court could somehow turn a person's own volitional acts against our defendants here. Our defendants were nowhere near involved, as I've already discussed, and AB herself was the factual and legal cause for her own injuries.
Right. It would be truly bizarre if you could be the instrument of the injury and then argue somebody a couple circles removed is the proximate cause.
Yes, Your Honor. So I don't think I need to speak much more to that. I think the court is unless you have anything else to add, Your Honor.
No.
So we have then immunity under the GTLA for failure to plead or failure to meet the gross negligence standard. Then, Your Honor, we have for both defendants, or both actions rather, we also argue that both PV and AV failed to plead in avoidance of governmental immunity. None of the exceptions apply, and governmental immunity is something that they need to affirmatively plead against, and they did not do so there.
Yeah, well, in fairness to them, I'm not even sure how they would get around the not the proximate cause argument you're making. I mean, I can't fault them for defective pleading. There's nothing to be said.
Right. I would agree, obviously, Your Honor.
And beyond that, they still have all the first level proximate causers, if you will, alive in Wayne County. I mean, it's not as if they go without a remedy. They just go to the people who are far more responsible.
Yes, Your Honor. I'm just making sure to get on the record all my.
No, that's fine. That's fine.
My second to last, well, just as far as immunity goes, we would also argue that defendants, Dr. Mellos, DeRose, Dr. Solke, and Petty are immune under 691.1405 parents 5, as they are the highest appointed the highest appointed executive officials at their level of government. If the court wishes or would require some more discussion of that, I can detail their positions and why we believe they are immune under parents 5.
No, I don't think you need to worry about that. I mean, the whole point of the GTLA and the way it's structured is to prevent exactly this sort of thing. Something catastrophic happened, and I don't think anybody would disagree that what happened was catastrophic. You can't just create this target-rich environment and go all the way up the line against everybody. I mean, you can't just sue the governor every time something goes wrong. It doesn't work that way. The focus of the waiver of sovereign immunity is that you fix responsibility on the people most directly responsible, not anybody and everybody who happens to be in the chain of command.
Yes, Your Honor. And then last, we would also be bringing, or we also brought a C8 motion, and the arguments under that part of our motion for summary would be basically the same things I discussed as far as negligence and proximate cause that, so it does not need repeating here, and we basically said as such in our brief.
Sure, and in exactly the opposite way that I handled the first motion, where I didn't think there was any basis for C7 relief, but I thought C8 was viable. Here, C7 clearly is the focus of the inquiry, because I'll let you go ahead and make your argument, but as I was reading this over last night, I thought, how in the world are they going to get around the requirement of the proximate cause? So thank you, Mr. Rothermel. I appreciate that.
Thank you, Your Honor.
So you can pick it up anywhere you want. As I say, I think what happened here was catastrophic, but that doesn't mean that you get to go after all these people who are supervisors.
Well, Your Honor, to Brother Counsel's point about specific or direct evidentiary proof, that's, I guess to show how this case is different from what he relies on, Tarlia versus Crabtree or Ray versus Swager. In those cases, they actually went through a period of discovery where, as indicated in the Court of Appeals opinion, they were able to conduct depositions to find out exactly what these particular individuals' responsibilities were and how they were involved.
I get it, but I mean, you've described the scenario as cleanly as you can, and I think accurately. I mean, we may be off by a couple ticks, but you basically have it. That there are people working at the facility that, to one degree or another, they give PV trouble, and then they turn AB loose on PV. AB attacks PV. PV has nowhere to go and suffers significant injuries as a result of it. All right, take that all as a given. How do you get up the line to all these people as the proximate cause when, at least in any telling of the story to anybody who is objective, AB is the principal cause? The people who are working at the Hawthorne facility are the secondary causes. And all these people who are in front of me now in this case are at most third level causes.
So to start, AB is not acting in a vacuum. Okay.
Sure.
Like, and in these cases, we've actually filed with the court the full video, not just stills.
Right. But
So-
right. All of that, if you were trying to convince me that they were a proximate cause, would be relevant.
Sure. But okay, so let me get there. This is all occurring, like the employees there, they're doing this right in front of AB. And more importantly for this issue, is they're doing it on a camera, like on video being recorded. In what world do employees do that? Unless it's, like, hey, anything goes. Like there is no, there's no sense of order in this facility. What occurred on that video is, I think I wouldn't be going beyond by saying we're all shocked by it.
Oh, it's horrific. I'm letting you go forward on a substantive due process claim because I think it's so horrific.
Sure. So, but in what world are employees like that emboldened to do that, knowing they're being videotaped? Now, I mean, counsel suggests like, well, they didn't know that there were cameras there. It's a state psychiatric facility. Things are being recorded,
I don't know.
So I think that's a reasonable
any
conclusion.
Lockdown facility that doesn't have video cameras everywhere.
So and that video is going somewhere. There's a purpose for it. Why have it? So that's where you get to this point of, you know what, like, there is, it could be reasonably foreseeable, or it is reasonably foreseeable that these employees were that emboldened and knew that no repercussions were going to come of this, or very minimal repercussions, but they went ahead and did it for their entertainment or voyeuristic enjoyment. it's a slow day.
Well, I think video cameras are there so you can capture these sorts of incidents, so you know exactly what happened. I wouldn't suggest that anybody in a policymaking position said, let's install video cameras for voyeuristic purposes. I mean, if you had a camera in a bathroom or a shower or something like that, then I'd agree with you, but.
No, I'm sorry, Your Honor, my comment for that was, that's the direct care workers, you know, like, it's a slow day, let's get this done. But they felt emboldened enough to do that and comfortable in their job. And you know, the video is just not going off site somewhere, because then, you know, what's the point? What's the point of taking up all that storage space on, you know, some mainframe? So and again, like with our ethical obligations and duties, like we've alleged what we could based on the information that we've had. And when you see Tarlia and Ray, those plaintiffs were entitled to the discovery period before the court made the decisions in their cases.
And I had a feeling you were going to say that, and I understand
Yeah,
that C7 is broader than just the pleadings. Okay, I got it.
Thank you, Your Honor. You know, in given that what has occurred here, like, it does meet the definition of conduct, you know, so reckless to demonstrate a substantial lack of concern.
Right.
You know?
Well, look, I'm not disagreeing with you in a general sense that the conduct here is horrific. I'm just trying to figure out how the law fixes responsibility. And I'm mindful of the fact that you still have live actions in the Wayne County Circuit Court against the people who are far more directly responsible for this.
Certainly. I mean, they're the people who carried it out, but there's also responsibility for those who let it happen. You know, because it's the environment that was fostered.
Well, I would agree with you that you can make a strong policy argument that there should be accountability for everybody who played a role. Unfortunately, the way that GTLA is written, having to be the proximate cause really forces you to limit the targets you get to go after.
But it's almost impossible to make that decision on the most proximate cause without having a benefit of any discovery.
Yeah.
And and it's not one rogue employee. Like we've named in AB's case, I think there's 7.
Agreed, right.
You know,
clearly,
so it's,
I've seen the pictures. There's clearly more than one person on site directly responsible for what's happening.
so as a group, so it's not just one person going off on their own. It's this whole unit, actually 2 units, that got together and decided that this was a good thing. Let's see what happens. So, does Your Honor have any other questions as to our position
No.
in response to?
Yeah, no, this one I'm going to write on, so I'm going to take more time. I'm going to be much more careful about it.
Okay, thank you, Your Honor.
Okay, thank you. I'll give you one more shot, Mr. Rothermel. Why don't you go ahead and?
No, Your Honor, I think I've said everything I need to say, and I think we are clear. I do have a couple housekeeping issues once the court is.
Sure.
May I proceed with those?
Yeah.
Okay. We have, 3 things, Your Honor. There is a witness list deadline currently in PV versus Dr. Mellos et al. That was because and that came from the Wayne County Circuit Court, one of the 2.
Oh.
In PV versus Mellos, that was in front of one judge, I think Judge Haggerty.
Right.
And that judge just issued a scheduling order right away. So there is a current, and it's my reading of the court rules that previous deadlines carry over to this court once it's transferred. So we would like the court just to be aware of there's a witness deadline of August 8th for PV versus Mellos to the extent that it survives.
All right. Well, if that's going to be a problem, feel free to extend it.
Okay.
If you can stipulate to an extension, I'll try to get this out fairly quickly.
I appreciate that.
But I don't want you to feel jammed up. That's not fair.
Yes, thank you, Your Honor. And then once plaintiffs are allowed to file an amended complaint in.
Oh, you're going back to the ones we argued earlier and I decided.
Yes,
Yep.
and because we didn't have, I didn't want to interrupt the
That's okay.
flow.
That's okay.
But once they're allowed to file the amended complaint in PV versus Department of Health and Human Services, will defendants be allowed to file a new motion regarding both summary or regarding both substantive due process and the 1722?
Sure, absolutely.
Okay.
Right, if they file an amended complaint, you can move for summary disposition again.
Okay, I just want to make sure that was clear.
Oh, yes.
And we just wanted to make sure that all deadlines are either vacated or we will be allowed to be allowed to stipulate to extend that or
right. I mean,
postpone.
Right, you now know where we are. The AV case is against the department is over. And so if somebody wants to appeal, that can begin sooner rather than later. The PV case I've indicated is going to be around for a while. And so I don't want you to feel rushed in that one. I'll sign a scheduling order that does almost anything that you can agree to. And if you can't agree, I'll be glad to talk to you about a scheduling order.
Thank you, Your Honor.
Okay, thank you. That takes care of all the housekeeping too?
Yes, sir.
Okay, you get the last word on everything, on merits and on housekeeping.
Thank you. First is demerits. Plaintiff's claims against the executive parties. In looking at it, we understand, and it appears Dr. Mellos and Michael DeRose are the highest appointed official. These other folks, we do take issue with that, only because just because you have a manager title or supervisor in your business name, it doesn't make you the highest appointed person.
Sure.
It's kind of like working at a bank with a vice president.
Right. Or a law firm where everybody's a partner.
Exactly. So I want to make that point. Then as to, and this is going back to the show cause orders, there's one more case I wanted to point your honor to with regard to the verified filing under 6434. And that's Chisholm versus State Police.
Does this apply to both of them or only to the PV case?
That would apply to both.
Okay. Give me the site again on that.
Chisholm, it's not been assigned a reporter yet.
Oh, okay. What's the docket number then?
So it's 355691.
Published?
It is published.
One of my sources of frustration that we're about 18 months behind on getting
say.
things out in soft bounds.
They're a little slow.
That's okay. We're working hard.
Yeah,
But yes,
it's true. It's true.
Right. I was chuckling the other day because I've been on the Court of Appeals now for well over 2 years and I still don't exist in the hard bounds yet. Maybe someday.
But with Chisholm, what I wanted to point out is this is where the Court of Appeals stated that this 6434 verification,
right. Yes.
it doesn't implicate the filing requirements of 6431.
Okay.
So with these complaints, at some point, they do need to be verified since they've been removed from state court. So we'd ask an opportunity to do that.
Right. As I said, I'm not looking to throw you out on those grounds. I'd much rather, if I'm going to send something up to my colleagues on the Court of Appeals, I'd much rather do it on the merits. And by the merits, I include C7.
Does your honor need supplemental briefing from the parties at all? Okay. Thank you so much for your time.
Okay. Thanks, everybody. This
Thank
has been
you.
really, really helpful. And I promise the orders will come out in the next day or two on what I've cleaned up already. And the opinions hopefully will come out relatively quickly. If you know how the Court of Appeals works, we each get to pick a month off every year. And I picked August. So this is now Court of Claims season for me. So I'm going to do my level best to get things out quickly. I still have some left over from April, but once I get through those, this will come ripping out. Okay. Thank you very much, everybody. Really appreciate it. Very helpful arguments.